Good evening, everyone. Can everyone hear me okay? Can you all hear me okay, or do I need to turn the mic up? A little bit higher? Okay. Hello? How's that? Is that any better? Okay, excellent. Thank you. Thank you, everyone, for coming out tonight. Before we begin our official meeting, unfortunately, I'm going to start off with a little bit of bad news for the members of CEPTA, the people of Emmaus. A wonderful gentleman that has been associated with CEPTA for many years and a resident of Emmaus for many years, passed away yesterday morning, Frank Zadrovich. So I just wanted to make mention of that for those of you that knew him. So if you wouldn't mind, I would just like to start off with a moment of silence for Mr. Zadrovich. All right, thank you. Then let's begin our meeting. We'll start off with the pledge to the flag. If everyone would please stand. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. A few housekeeping notes here before we begin. If this is your first time here, restrooms are over on the left-hand side here, my left, your right. We'll have some snacks available after the meeting. There's also coffee and water in the back if you need a beverage. I mentioned in the email, I don't know if everyone had received it, that we were going to do some petition signing. So you may have seen people walking around with clipboards. If there's someone that you're interested in signing a petition for, please see these people after the meeting and help them get on the ballot, because it's what keeps our process working, especially people that would be willing to come to a Second Amendment meeting and meet with us, because those are the people we need in office. This evening, we're continuing our membership drive for all members of CEPTA. If you haven't paid your dues yet this year, please see Julia and get your dues taken care of. And if you're not a member of CEPTA and you'd like to join, we'd be glad to have you. The membership is $15 a year, and that includes a subscription to the Lehigh Valley Commentator. So there's free copies over on the left-hand side. If you want, you could grab a copy so you could see the quality of the newspaper. Next month's meeting will be on Tuesday, March 17th. The topic is not settled yet, so that'll be announced. A couple important local issues to mention. East Penn School District has started their budget season. The preliminary budget was passed last week, and it contained a greater than 5% tax increase. According to the superintendent, the majority of the tax increase will be used for salary and benefits. So there goes the myth of tax increases for education spending. A second issue, I don't know if everyone here is familiar with HB/SB 76. Those were House and Senate bills in the last session having to do with property tax elimination. There is going to be a memo that's going to be introduced soon to reintroduce the legislation again so we can try to get that passed. Currently, it has 8 sponsors. They are 4 Democrats and 4 Republicans. So if you could contact your legislators to see where they stand on property tax independence, that would be great. Let's push them in the direction of eliminating school property tax. And finally, we'll move on to tonight's agenda. Unfortunately, due to the weather, Miss Lexi Rusnick from the NRA was not able to make it up. She was down in Virginia, and apparently they had gotten a lot more snow than we did, so she was unable to make the drive up. So fortunately for us, we have Mr. Joshua Prince from the Firearms Industry Consulting Group joining us this evening. He'll give a presentation, answer your questions. Also, we have Dustin here from Representative Justin Simmons' office. So if anything in this conversation this evening strikes you and you think that we should have some legislation introduced to repeal or introduce something for firearms, let
Dustin know, and he can take that information back to Justin Simmons. So at this point, I'd like to turn it over to Mr. Prince.
Thank you. How's everyone doing tonight? Good deal. I know I'm not Lexi, so I apologize for that. But hopefully I'll be able to give you guys all the information that she would have given you and then some. I know that there were a number of issues in the email that were going to be addressed tonight. I anticipate reviewing all of those. If you have questions beyond that, feel free, ask. The general rule is that if you have a question while I'm presenting, go ahead, raise your hand. We'll get the mic to you and answer your questions. Don't feel like you have to hold your questions until the end. So with that being said, let's get into the nuts and bolts of all the different issues while we're here tonight. A lot of you have probably heard that there is a proposed bill, HB 418, that was introduced by Representative Kirkland of Delaware County that would prohibit the use of human silhouette targets. And it is a very simple bill in that it is not very long, and that it would encompass your ability to use a human silhouette target pretty much anywhere within the Commonwealth unless you were law enforcement or military. Yes, they believe, well, at least as far as Representative Kirkland believes, they are better than you. He believes that the only types of targets that anyone should be able to have are elk, deer, squirrel. He had a listing of several different animal species, turkey, and then basically had limited it to those. So I would highly recommend any of the bills I discussed tonight that you reach out to these representatives and let your voice be heard. Let them know that you don't appreciate these types of bills being introduced, or in some occasions where we have very pro-Second Amendment bills, please reach out and let them know that you support those bills, because that's just as important. We're going to have an uphill battle this year with Governor Wolf being in office. I'm still trying to figure out how that happened, but nevertheless, it is where we are at today. It'll be interesting to see what, if any, bills that are passed will be vetoed by him, but I can say that we have elected a very pro-Second Amendment General Assembly in general, and there is a good feeling throughout most of the Commonwealth that many of the pro-Second Amendment bills may be passed, and even if vetoed, that we could override the veto. Did you have a question, sir? Hold on one second while we get the mic.
You'll need the mic. Are my targets that I own now that are silhouette targets, are they going to be grandfathered? Are my targets that I own now, which own a couple hundred man targets, would they be grandfathered under this bill where I could still use those targets?
No, there is no grandfather clause under the bill. It would not prohibit your possession of the targets, but it would prohibit you from ever being able to use them at a target range. And a target range is any parcel of property that is ever used for shooting in any capacity.
So my personal range, I couldn't even use them on my own property, on my own range.
That is correct.
That's great.
Absolutely.
This guy must be a Democrat.
You think? Yes, ma'am. Go ahead.
Does that mean the small bullseye that you use at 75 feet and that sort of thing too?
So the regular NRA targets or distance targets would not seemingly be included in this. However, the concern is that Representative Kirkland did specify that appropriate targets were, again, turkey, deer, elk, things like that. But the bill itself speaks to human silhouette targets, so there should not be any issue with that. But the issue that we frequently see is judicial activism, where although the statute does not speak to something, the court decides that it will legislate from the bench and include such a provision. So that's why it's imperative that we ensure that any legislative language is extremely clear.
So they only want me to shoot at something that won't shoot news?
Correct.
Attorney Prince, digressing back to what you said, in the event the governor does veto legislation, is there 2/3 majority of both the House and the Senate of the Republicans who do that? I just didn't count the numbers during the past election.
There is, but one has to also understand the fact that depending on what the bill is, may depend on what all Republicans, as there are, as I like to say, Christie Republicans, who really aren't Republicans, but rather Democrats in a Republican suit, that will not toe the Republican line or conservative line. So that's why it's really going to come down to an issue-by-issue situation or count to determine whether a veto could be overridden. Another bill that's currently pending, and this one should have everyone really concerned, is House Bill 285, introduced by Representative Thomas from Philadelphia. He is proposing that if you have ever sought mental health treatment, just mental health treatment, you should be prohibited from ever being able to own a firearm or ammunition.
Is he from Jersey?
No, Philadelphia, just across the river, and that's the problem. He's drinking the same Kool-Aid. So yeah, his bill proposes that if you've ever had any mental health treatment, what does that mean? He says it also includes inpatient and outpatient treatment. So if you go to your general practitioner and say, "Doc, you know what, I'm having a hard time right now. The sun's not out as long. We're in the winter months. I'm feeling a little bit blue." Ostensibly, you just asked for mental health treatment, and you would be forever prohibited. And quite honestly, standing here before you, I can tell you, if there's a person in the audience who can get up and honestly say that throughout their entire life, they have never, ever felt depressed, I'll fall over. Because I truly believe that in order to understand and appreciate true happiness, you have to have felt the opposite. You have to have felt depression at some point in your life. And that's just part of being human. And there's nothing wrong with it. And we shouldn't be dissuading individuals who maybe need help from seeking that help. That's exactly what this bill would do. This bill would tell anyone who is going through a rough time that the worst thing you could do is seek out any type of medical treatment, because if you do, you're going to be prohibited for the rest of your life from ever being able to own a firearm. Period.
How about HIPAA?
So the questions with regards to HIPAA, there are questions about whether this bill would violate specific terms of HIPAA, but the problem is how they're attempting to get around it is requiring that people respond on the state form as to whether they've ever had mental health treatment. They're not requiring that the individual submit their medical records. If you misstate that, and it's questionable how the Pennsylvania State Police could truly capture the data as to whether someone's had mental health treatment. But let's assume that they can. If you get denied because you made a false statement on that form and you at some point in time had sought out mental health treatment, it would be a felony of the 3rd degree. So keep that in mind. Please let Representative Thomas know your thoughts on his proposal. Again, that's House Bill 285. Another one that's out there is House Bill 91, and it involves false compartments in vehicles. This has been introduced by Representative Harper. And you may say, well, false compartments in vehicles, well, clearly, that's got to be the drug runners and that. However, when you actually look at the proposed bill, it paints a very different picture. If you've ever had a Chevy Avalanche or a Cadillac Escalade EXT, they have in the back on the rear fenders these little area spaces that's actually designed so that you can put ice in and cool things down or just storage compartments. Under this law, those would seemingly violate it. If you affix a gun vault in your car, maybe just for a handgun or that ostensibly would violate it. And by violate it, I mean he's looking to make it a prohibiting offense. He wants it at least to be a misdemeanor of the first degree if you are found in possession of one of these secret compartments. And that would prohibit you, under federal law, for the remainder of your life from ever being able to possess a firearm. Yes, in the back.
Yes, and in that legislation, does it also include confiscation of the vehicle?
Off the top of my head, I don't remember, but I believe there was a provision, at least last year when it was proposed, I believe there was a provision for the forfeiture of the vehicle.
I thought I had read that somewhere, so thank you.
Yeah, I believe that to be true. Yes, sir.
Does that mean a factory glove compartment in your dash?
Does that mean a factory glove compartment in your dash? That was exempted, but ostensibly, depending on how you utilize it, could change that outcome. So you may have a glove box. If you just put your handgun in, you'd be fine as long as you had a license to carry firearms. But if now you put a gun vault in there to hold your handgun while you're in the car that's lockable, ostensibly now you're in violation of this proposed bill. So again, there's a lot of reason to be aware of these different bills that are pending and to make sure that you make your voice heard as to this legislation. So, yes, sir.
There have to be a great many people who actually carry valuable goods with them in their cars. Jewelers are the obvious statement, but there are many people carrying specialized documents. These people often have special ways of hiding them in their car. Therefore, the law is just nuts.
I completely agree. The comment was basically that there are a number of different professions that have to store valuables in their vehicle and have ways of doing such so that other individuals aren't aware of the fact that those valuables are within the vehicle. And that's absolutely true. Again, what Representative Harper is anticipating is that people will just think of the drug dealer and say, oh yeah, this is in the best of the public's interest to move forward and not have secret compartments. And that is the furthest from the case. Also, as I touched on earlier, the real concern is not necessarily just strictly the language of the bill, but how it's going to be interpreted by the courts and where it's going to end. And that's the real concern, because ostensibly, in some regards, it's giving a blank check to the courts to interpret it and find that all sorts of compartments now constitute secret compartments that would be a violation of the law. So you want to make sure to oppose that. And again, that was House Bill 91, introduced by Representative Harper. Now let's talk about some good bills. And by no means am I going over all the bills that are currently pending in the House or Senate regarding either anti or pro Second Amendment legislation. There are many. But I want to talk about a couple. House Bill 45, good number, introduced by Representative Saccone. It is justification. And basically what this intends to do is address the situation under our self-defense provisions where an individual would be able to use lethal force against someone who may not have a weapon. Maybe from their sheer size, weight, or ability, they could cause serious bodily harm or death to you, and there's a disparity there. Also, if there are multiple attackers, then you would have the ability to use force. So again, these situations generally most people think of in the context of a young lady who is approached by, a 250-pound guy who obviously may not have a weapon, but his body and his weight is sufficient for her when she's maybe 100 pounds that she doesn't have an equalizer. She doesn't have a way to defend herself against that individual. And this legislation would address that and say that if the individual, the person being attacked, the victim, reasonably believes that this person could inflict serious bodily harm and has an ability to do that, they could use lethal force. Right now, as we stand here today, the law doesn't say that. There are arguments for it. in the absence of the actual text of the statute stating such. I actually have an article that I co-authored with Alan Thompson, who's in the room with me tonight from our firm, on the inalienable use of force that's being published by a law school down in Florida. Hopefully in the next couple months that'll actually be published, but it goes over the history of the use of force and the fact that historically there never really was this idea that you had to retreat. Generally, what our forefathers believed was that if someone came at you and intended to harm you, you could use all forms of force, including lethal force. In fact, one of the examples was given was that if someone was in a bush and you walk by and a person jumps out to attack you, it was perfectly legal to use lethal force at that point to kill that person because they intended you no goodwill. Where the idea of retreat came in was in relation to where you had caused the altercation. The example generally given is if you're at a bar and you shove someone, they shove you back, you can't now pull your gun and engage them because you were involved in starting the altercation. In that situation, what they would say is you had a duty to, quote, retreat to the wall, meaning you had to go back and try and prevent escalation of the situation. In retreating to the wall, if they continued to come at you, at that point you were actually authorized to use lethal force, even though you had basically caused the altercation. But that's where this whole idea of retreat came from. And it's a misconception and a misapplication of the law over all these years to say that a law-abiding citizen who had no effect on causing the altercation had to retreat in any capacity. So that'll be coming out shortly, but that's a little background for you on use of force and what I believe to be the inalienable right to use lethal force in defense of yourself. Another bill to be aware of is House Bill 130, which was introduced by Representative Tallman, and this attempts to destroy the records that the Pennsylvania State Police is keeping in what I believe, although the Pennsylvania Supreme Court differs, to be a violation of the law. Currently, it is illegal for the Commonwealth or any agency thereunder to maintain any form of registry of firearms. The Pennsylvania State Police keeps a database, I guess is what they call it, of handgun sales and some other items as well. Those records under the statute are actually supposed to be destroyed in 48 hours. The funny aspect is that the Pennsylvania State Police, last I heard, is about 3 to 4 weeks back in even processing them. So actually they would have to destroy the form before they could even put it into their system. However, they continue to maintain this database. This case went up to the Pennsylvania Supreme Court, and what the Pennsylvania Supreme Court said was, well, this isn't a registry because it doesn't have a listing of every handgun or firearm that is in the Commonwealth and who it's owned by. It's a partial listing, and it can't be used in any civil or criminal proceeding, so it's okay for them to retain it. So this legislation would specifically address that situation, tell the Pennsylvania State Police that they must destroy those records, and only allows them to keep certain records for purposes of tracing firearms and keeping database of stolen firearms, things that federal law already permits and allows. But again, to the surprise of most people, both under the U.S. statutes and under Pennsylvania's law, it is illegal for either the U.S. government or for Pennsylvania to keep and maintain any form of registry of firearms. Yes, sir.
But doesn't the seller, such as Cabela's or the local gun dealer, isn't he required to keep those records forever?
Not forever. The question was, as a federal firearms licensee, don't you have to keep certain records for certain durations regarding the sale and disposition? That's generally referred to as an acquisition and disposition book by gun dealers. And the answer is yes. They have to keep who they received it from and where it was disposed of too. But those records remain there with the dealer unless the ATF comes in with a warrant for specific information. And it's still limited, as here in Pennsylvania, there are a number of occasions where we can transfer a firearm to another individual without needing to go through a federal firearms licensee. So there isn't going to be an absolute registry of firearms, because there are a number of ways that someone can lawfully come into possession of a firearm without needing to go through a gun dealer.
What would an example of that be?
What would be an example of a way to come into possession lawfully of a firearm? So the first aspect to understand is that here in Pennsylvania, generally when we're referring to a firearm, we're talking about a handgun. Okay. This surprises many people, and it surprises a lot of criminal defense attorneys and many judges, as I've been brought in to assist in situations where a criminal defense attorney was ready to plead his client guilty to a crime that the client had not committed because they never thought to look to the definition of a firearm. So, example of a situation would be with a rifle. If I have a rifle, I want to sell it to another Pennsylvania resident, we could just meet somewhere. As long as I have no reason to believe that person is prohibited under state or federal law from possessing a firearm, we can do an in-person sale. With a handgun, generally you always have to go to a federal firearms licensee, again, because it's a firearm under Pennsylvania's laws. However, there are certain familial exceptions. So a grandfather can give to a grandchild, grandchild can give to grandfather, spouses can give to one another, parent can give to child, child can give to parent, and that's pretty much it. The one aspect that's noticeably missing is siblings, giving to a sibling. So son could give to dad who could give to daughter, but ostensibly, per the language in the statute, it doesn't say son can give directly, or brother can give directly to sister. I think it was intended by the General Assembly, but it's not specifically stated. So that's one exception to be aware of. But again, with the rifles and shotguns, we could do an in-person transfer as long as I don't have any reason to believe you're a prohibited person. Other current bill pending, House Bill 230. This is one everyone should support. This would do away with the requirement for any individual to obtain a license to carry firearms here in the Commonwealth in order to carry a firearm. As long as you're a law-abiding citizen who can own a firearm, just like in Vermont and Alaska, you could conceal carry or open carry without need to obtain a license. Additionally, the law provides for an optional license, and a lot of people have said, well, why would there be an optional license? The reason for that optional license is there are a number of states that offer reciprocity, but only if you have a license from your home state. So in those situations, you would need that license from your state. The nice aspect, at least as the bill currently exists, is that we would be doing away with this nefarious character and reputation clause that we find within our statutes in regards to the issuance of a license to carry firearms. Nowhere within the statute, the Uniform Firearms Act, does it state what constitutes character and reputation. And in fact, what we find is different issuing authorities, generally it's the sheriff, except for in Philadelphia where it's the chief of police, they all have different interpretations of what constitutes character and reputation. In Berks County, Sheriff Weekneck's a very pro-Second Amendment sheriff, and quite honestly, unless there is something that he's aware of that that person did outside the scope of being a prohibited person, you're going to get your license to carry firearms. Whereas if we go to Philadelphia, the standard operating procedure is the person doesn't have good character and reputation, and you almost have to prove that you do have good character and reputation. So we have a lot of issues in that regard with character and reputation. I actually litigated a case up to the Commonwealth Court on the character and reputation clause, and I said it violates equal protection because In Philadelphia, simply being convicted of a summary disorderly conduct, they'll contend constitutes bad character and reputation, but in Berks County, it's not an issue whatsoever. So how are we applying the law equally to all residents of the Commonwealth? Commonwealth Court didn't really want to hear that. So unfortunately, they said, we're okay with that. So that's why this legislation is much needed. It would allow anyone to be able to conceal carry a firearm or open carry a firearm without need for a license to carry, and additionally provide for that optional license if you're in a situation where you do need one. Again, that was House Bill 230, and that was another bill that has been proposed by Representative Saccone. Representative Saccone is a very ardent supporter of the Second Amendment, as is Darrell Metcalf. There's a number of representatives in the General Assembly that are very pro and staunch Second Amendment supporters. It's important to let them know that you appreciate those aspects. I also believe that Representative Saccone will be coming out with a new bill in the near future regarding the Mental Health and Procedures Act here in Pennsylvania. We have a lot of issues with our Mental Health and Procedures Act. A lot of people are surprised to learn that an individual can be taken to a hospital and involuntarily committed without any form of due process. Basically, all that has to occur is the doctor has to sign a form after doing whatever evaluation the doctor deems appropriate, stating that you need to be committed. And people say, well, how does that violate due process? Well, you're not provided an attorney. You're not provided an opportunity to cross-examine anyone who's making statements against you. You're not provided an opportunity to submit any evidence. You do not get a neutral arbiter, in my opinion. And many people say, well, how's that? How the doctor doesn't know you, he's neutral. Well, if you actually do research, what you will find is there are certain hospitals here in the Commonwealth that have never found someone who didn't need to be involuntarily committed. And it's merely because of the amount of money that they receive from the insurance carriers for the involuntary commitments. There are plenty of hospitals that are making millions of dollars a year just off of involuntary mental health commitments. And simply based on that involuntary commitment, which we call a 302 here in Pennsylvania, that will prohibit you currently under state and federal law from ever being able to possess a firearm. So we are going to have some challenges. I actually received some funding from the NRA Civil Rights Defense Fund to file challenges, federal challenges, to whether a 302 and also the next level 303 can trigger a permanent disability of an individual. We have 2 individuals who, under federal law, can possess a firearm in their official capacity as a law enforcement officer, but are prohibited in their private life. So we have individuals who, one is a Pennsylvania state trooper who was 302'd and 303'd a number of years ago. He came back on duty. The psychiatrist with the PSP said, yeah, he's great, he's fine. He has an AR-15, Glock handgun, Mossberg shotgun every day in his cruiser when he goes out. No one has any concern whatsoever about him. He ranks in the top 10th of a percentile within the entire Pennsylvania State Police with regards to his shooting ability. Yet, the second he clocks out, he's a prohibited person, can't possess a firearm. The other individual was committed as a juvenile, and we see this very frequently. There's a lot of times where parents don't know what to do with their kid. Or, unfortunately, and this may come as a surprise to many in the audience, I have seen on a number of occasions where the parents want to go on vacation and they involuntarily commit the child so that the child has someone to watch them while the parents are gone. That juvenile commitment, same as an adult commitment, disables that person for the rest of their life. The other plaintiff that I referenced went on after this juvenile commitment to serve his country honorably overseas on a number of tours, was part of the 82nd Airborne, came back stateside, and finds out that he can't possess a firearm. He had explosives over in Iraq, but coming back to Pennsylvania and here stateside, he's prohibited under federal law from being able to have any firearms in his private capacity. So we are going to see a number of challenges this year to those types of laws and whether they violate the Second Amendment. There was a decision by the Sixth Circuit Court of Appeals, which is out west. It has no applicability here in Pennsylvania. But in that decision, the Federal Circuit Court of Appeals found that a single isolated involuntary commitment was not sufficient to trigger a disability for the remainder of that individual's life. That just because someone's having a hard time and might be involuntarily committed on one occasion doesn't mean that that person is one who is incompetent or has a mental disability or other issue ongoing. So we're going to be challenging those laws this year. So that's some of the new bills that are currently pending. Some of the other issues that we're currently dealing with is something called Act 192, which was passed last year in the General Assembly. And before I get into what Act 192 is, I want to give you a little bit of the background to Act 192. Approximately a year and a half ago, there was an individual, Justin Dillon, up in Erie, Pennsylvania, who wanted to have a Second Amendment rally at a park in the city of Erie. Now, he has held numerous Second Amendment rallies in that park before, always without incident. But this time, the solicitor came back and said, you know what? You can have your rally, but there can't be any firearms present. Because in the 70s, we passed an ordinance that said you may not have any firearm in the city parks. And I had responded to him and said, you know that your ordinance is illegal under the law because the law since 1974 has said that no municipality may regulate in any manner, among other things, the possession and transport of firearms or ammunition. He's carrying a firearm in a city park. You're regulating possession and transport of that firearm, which is something you cannot do. And oh yeah, by the way, under Section 6119, it's a misdemeanor of the first degree for any municipality to enact or enforce such an ordinance. Well, that did not dissuade them. So we filed a civil action asking the Court of Common Pleas of Erie to enjoin the city from enforcing its illegal ordinance. And much to my surprise, the president judge was assigned to our case, and in refusing to grant our injunction, specifically left out words of the ordinance that were directly applicable to the prohibition. So he left out the words possession from the ordinance, because if he included them, on its face, it clearly violated Section 6120. So we had to take an appeal up to the Commonwealth Court. At this point, the city of Erie decided to charge Mr. Dillon and 7 others for being in violation of the city ordinance because they went forward with the rally and allegedly had firearms at the park. And I say allegedly because in representing those 8 in front of the magisterial district judge regarding the charges, all the officers testified that the only thing they could testify to was that there were items that looked like firearms, either strung on one's back or in a holster, but they never checked to see whether they were actually firearms or not. They couldn't say whether there were any serial numbers on them. They couldn't say whether there were any magazines that were even loaded in the park. And after explaining to the judge, the magisterial district judge up there, that it's preempted, state law says that they can't have this ordinance, after bringing up the issue that the city had failed to even ask the judge to take judicial notice of the fact that there was an ordinance. There was no legal basis established at the hearing that there was any ordinance that they had violated. And telling the judge that the police had failed to establish that there was even a firearm in the park that day. What do you think that magisterial district judge did? Nope, he found them all guilty. You getting a trend here in Erie? So we appealed up to the Court of Common Pleas, the same place where we started with the civil case. And the judge that was assigned was different than the president judge, and she had some concerns over the charging when we filed our motion to dismiss the charges. As the Commonwealth Court was reviewing the issue, she elected to stay any decision until the Commonwealth Court decided the matter. The Commonwealth Court would come down with a decision stating once again that we've told you time and time again, as there's a number of cases out there, that municipalities may not regulate, among other things, firearms and ammunition, and your ordinance is in violation of that. Therefore, the ordinance is struck down. At that point, the city decided that it would withdraw the charges against my clients. The problem was, my clients had no right to recoup their attorney's fees, costs, damages, nothing. Nada. So the General Assembly found out about this. And the General Assembly was already frustrated. Even prior to this, the General Assembly had proposed bills that would change and allow for attorney's fees and costs and damages and things like that. But this really irritated the General Assembly because they said, we've told you time and time again you can't do this. It's criminal. The Erie County District Attorney won't even prosecute the city officials responsible for enforcing the ordinance. So if our district attorneys aren't going to hold our publicly elected officials accountable, we have no other option but to provide a mechanism for relief by the individual. So they passed what became Act 192. And what Act 192 said was that any person who's aggrieved or a membership organization could file a civil action seeking declaratory or injunctive relief to prevent one of these ordinances from being enforced. And it specifically said that all the township had or municipality had to do was promulgate a rule, regulation, ordinance. They took painstaking measures to encapsulate within the bill all the different possible words that could be utilized by a municipality in putting forth some sort of restriction on firearms or ammunition. So now, a membership organization like the NRA, Firearm Owners Against Crime, Concerned Gun Owners of Pennsylvania, Lehigh Valley Open Carry, and the names continue on, could all go and could challenge these ordinances, as well could an individual. You don't have to be from that municipality to challenge its illegal ordinances. And additionally, if you were successful, you have entitlement to attorney's fees, costs, expert fees, and damages. Well, this really upset the city of Philadelphia, city of Lancaster, and city of Pittsburgh, the main violators of the law. So it doesn't matter to them that it's criminal for them to have these ordinances and enforce them, but when this law was passed, they now wanted to challenge whether it was constitutionally passed. So there is currently a lawsuit pending before the Commonwealth Court regarding whether Act 192 was constitutionally passed. I believe oral arguments scheduled for April 6th, and God knows when we might have an answer from the Commonwealth Court. But regardless of what that answer is, everyone has a right to appeal to the Pennsylvania Supreme Court because it's starting at the Commonwealth Court. So you're always entitled to one level of review. What that means is it could be in excess of 3 years before we have any idea as to whether Act 192 was passed constitutionally or not. As a result of the passage of Act 192, I was retained by a number of organizations: Firearm Owners Against Crime, American Gun Owners Alliance, Pennsylvanians for Self-Protection, and Concerned Gun Owners of Pennsylvania, to attempt to get these illegal ordinances off the book without suing the municipalities. The thought was, we don't want to burden the taxpayers, because we all know, regardless of whether the municipality has insurance, the taxpayers will end up having to deal with the burdens, because we know that if there is an insurance carrier and they're successfully sued, or even if they're not successfully sued, they're going to incur attorney's fees in defending. They're going to either up the insurance rates, or they're going to kill the plan for the next year and require that they find a different insurance carrier, and clearly the rates are going to be more expensive. For those municipalities that are not insured, obviously it's going to flow through directly to the taxpayers, kind of like Harrisburg. So we've been very successful. We sent out over 100 letters to different municipalities wherein I went over the statutory law changes with Act 192, all the case law that says that you cannot regulate the possession or transport of firearms or ammunition. In fact, we have a case from the Pennsylvania Supreme Court, a case called Ortiz, where the Pennsylvania Supreme Court went a step further and said that the regulation of firearms is constitutionally protected, and that only the General Assembly may regulate firearms and ammunition across the Commonwealth, because it's an issue of statewide concern. We don't want a patchwork of laws across the Commonwealth where no individual could comply with them, because there's no ability for that individual to know what those laws are. So that was kind of the background. And as I said, we, at this point, probably have over 60 municipalities that have contacted us back and have repealed their illegal and unlawful ordinances, which is the exact result we wanted. There are a number of other ones that we haven't yet heard back from, and we are going to be following up with them, but it's been a lot of work. Now, on the other side of the coin, we had the city of Harrisburg, after receiving our letter, that said, you know what, we don't care. You can sue us if you want. So we were preparing that lawsuit, and we were preparing to litigate it so that there could not be an argument that it needed to be stayed while the Commonwealth Court decided Act 192. Basically, what we were preparing to do was establish standing under the old Section 6120, just like we did up in Erie, and argue that even if the Commonwealth Court were to invalidate the new changes, you can stay the aspect of attorney's fees in that, but we get to get this law off the books or enjoined from prosecution or enforcement. There was another organization, U.S. Law Shield, that kind of jumped the gun and filed a lawsuit against the city of Harrisburg. In their press conference, they said they had to be first because it was just a matter of time before someone else filed. They only argued Section 6120. They did not argue Article 1, Section 21 of our Pennsylvania Constitution, which is our Second Amendment provision. Why that's important, as I alluded to earlier, the Pennsylvania Supreme Court in that Ortiz decision said it's constitutionally protected. It didn't say, that's correct, it did not say that it was statutorily protected. Our preemption code is a statute, Section 6120. So that was a glaring issue. The other issue was that they challenged their discharge and other ordinances and never raised a Second Amendment challenge to them. In D.C. v. Heller, the main U.S. Supreme Court on the Second Amendment, The U.S. Supreme Court said at the core of the Second Amendment was the right to self-defense. In the city of Harrisburg's ordinance regarding discharge, there's no exception for self-defense. It's a blanket prohibition on discharge of a firearm, unless you're law enforcement. Equal protection, anyone? But anyway, that clearly violates the core of the Second Amendment, because now I can't defend myself because I'm prohibited from being able to discharge my firearm. And the city says, well, we're not going to enforce that, against the law-abiding citizen. But you know what? The same argument was made by the District of Columbia in D.C. v. Heller, saying, if someone puts together their gun in defense, we clearly understand that self-defense, even though it's not enumerated in our provisions, we clearly understand that, that's an exception to the rule. And the U.S. Supreme Court said, no, it's not there. We're not considering it. It's not part of your ordinances. So we then rushed to get our complaint finalized. We probably do not have all the aspects of the case covered as we originally had hoped to, but we wanted to ensure that all the issues were properly before the court at the same time, so that we didn't have one decision that really eviscerated our rights by the time we get our lawsuit filed. There was a preliminary hearing on their lawsuit a couple weeks ago, about a week and a half ago. We're waiting to hear from the judge what the judge is going to do with that preliminary injunction. There's also some issues because the attorney representing the individuals challenging the law is also part of the litigation. So the city of Harrisburg has moved to disqualify him based on a conflict of interest. That wasn't so surprising, but apparently the plaintiffs never saw that coming. So that's an issue that the judge is currently dealing with, as well as whether to stay the matter until the Commonwealth Court decides Act 192, the exact issue that we wanted to be able to circumvent by establishing standing. So that litigation is moving forward. We actually just had the city of Harrisburg attempt to move our case to federal court because of our Second Amendment claims. And I can't give everything away, but I think the city of Harrisburg is going to be in for a surprise in the next week or two with regards to their desired removal and their failure to, as I'll say, hire competent counsel to make that possible. So it'll be interesting to see what all happens in the upcoming weeks with that, as well as what, if any, action the judge takes on the preliminary injunction. So that's a little bit about Act 192. Like I said, my clients have really just wanted to make all the municipalities comply with the law as it's existed since 1974. We don't think that's unheard of or unreasonable. All we're doing is saying that it's been a misdemeanor of the first degree for you to enact or enforce this ordinance since 1974, and we want you to repeal it off your books. Also, the other interesting thing that has arisen in sending out these letters is a lot of municipalities have held hearings and they've asked their police chief to come in and speak on these ordinances and whether they have an impact on deterring crime. I have yet to hear, with the exception of Harrisburg, from any police chief that any ordinance enacted by a municipality has had any effect on deterring crime. In fact, in 90% of these scenarios, there are state law crimes of a misdemeanor and felony nature that can and are charged as well. And if those are not sufficient to dissuade an individual, a criminal, from violating the law, clearly a summary ordinance akin to a traffic ticket is not going to be sufficient to dissuade that individual. The only reason for those ordinances is to ensnare law-abiding citizens who aren't aware of the provisions and have an ability to charge them. So, as I said, we'll wait and see what all transpires with regards to Act 192. Is there a question?
Yes. I follow PennLive.com, and there's a few articles, what you're saying is spot on. But I was reading one of the paragraphs that said there was another law that was passed by the General Assembly that actually had two things tagged to it, if you will, just like 192 with the metal, and then there was something else. I forget what it was, but I'm just curious with your professional opinion, because one other one was like this. What do you think
So the question is, with regards to the bill and the challenge to the constitutionality, there is a provision in our Constitution that says generally that any bill shall be a single subject bill, and that the title of the bill shall incorporate what it's in relation to. With regards to Act 192, there's no dispute that the title incorporates everything that it's entitled. It's a long title. But originally, it was in relation to scrap metal, which comes under Title 18, our Crimes Code. As does our State Preemption Code. It comes under Title 18, Section 18 PACS, Section 6120. So the question is, single topic, it's within the same title, which is generally thought to be what was required. And the problem is, when you look at the case law has a bunch of different responses to the issue. And there is no clear-cut explanation to whether it is constitutional or not. I think clearly, based on my review of the case law, that it is constitutional. There are clear ways to differentiate those cases where the court found that it was outside of the single subject rule, usually where it involved multiple titles. But, you know, again, I don't wear the black robe. I don't get to sit up there in judgment of it. I get to litigate the cases and bring the issues up to the court. So we'll have to wait and see what happens, but I can't definitively say either way.
But I think you hit the main point by under Article 18 or Title 18.
Right.
That was,
and there is one other exception under the Pennsylvania Constitution. It does provide for appropriations bills and for consolidating entire sections of the law. So there may be some issues with appropriations, although a lot of people don't think of this as saying, how's this appropriation oriented? This was actually sent to the Appropriations Committee and was there for a substantial amount of time. So we'll have to wait and see what all arguments are made and how oral argument goes. But at this point in time, we're just waiting and seeing. Yes, sir, in the back.
Yes, I understand that Governor Wolf has been perceived as anti-gun, anti-Second Amendment. Do you have any idea what proposals he has made? For example, I know there's been talk about magazine capacity issues. Do you have any idea what issues he's planning to propose?
I don't think he has found a gun restriction bill that he wouldn't support, quite honestly. I think if there is any anti-Second Amendment legislation, he will be more than happy to put his John Hancock on it. That's my own personal opinion based on what I've seen and heard. If you look at the individuals that he's looking to appoint to positions such as the Pennsylvania State Police Commissioner, who, oh yeah, by the way, is from Maryland. Maryland, anyone know about Maryland's draconian laws? That's who's going to be our new PSP commissioner. Well, we're hoping that the Senate doesn't ratify his confirmation, which is another issue to reach out to your representatives, your senators, and make sure that they're aware that you don't support his confirmation in the Senate. But these are the types of individuals that we see that Wolf is attempting to put into places where they could have a substantial impact on our rights. Yeah.
Do you know that man's name?
I'm forgetting it off the top of my head. I apologize. If you search and do a Google search for Pennsylvania State Police Commissioner and Wolf, I would bet it'll be the first up because I know a lot of people have been making a lot of noise over it because there is a lot of concern. And I know Firearm Owners Against Crime is trying to get people together to contact their senators to oppose his confirmation. But yeah, I think if you look online, you should be able to pull it up quick. I know there was also, I think someone had placed his home on Google Earth or something, and they were showing pictures of it with the unmarked car out front. Yeah, Alan. He has it.
Marcus Brown.
Marcus Brown, that was his name. That's right. He's the individual from Maryland who may be our new PSP commissioner. Yes?
Is a provision that would prohibit the discharge of a firearm in a park?
I believe it is not. If you look at the case law, not just Section 6120, but also the case law, I believe it's been clear from the Pennsylvania Supreme Court in Ortiz that all regulation regarding firearms and ammunition is prohibited, that only the General Assembly can enact those types of provisions. Additionally, as I alluded to before, if it's an absolute ban on discharge or just has exceptions for law enforcement or such, it clearly violates DCV Heller because I can't use it in self-defense. So you have a Second Amendment issue clearly there, just like City of Harrisburg. Any other question? Yep.
With that mental health bill, what concerns me is there's a lot of veterans out there, and could that arresting officer put that suspect in for 302, 303?
Yes, depending on the circumstances, if the officer believes that the person needs to be evaluated for potential involuntary commitment, that officer could take that individual into the hospital and have them evaluated, sign, the 302 petition stating, based on his or her observations, and then it's up to the doctor. So that's why it's important. I mean, if anything like that happens, you definitely want to try and get in touch with an attorney who knows what they're doing, because the response is to get another psychologist or psychiatrist in there to evaluate you as soon as possible and to get a differing opinion to say, look, this was just an ER doctor not trained for doing full-blown psychological evaluations. The other concern or real issue that we see in a number of occasions is an individual is brought in and involuntarily committed while they're under the influences of drugs or alcohol. Any psychologist or psychiatrist will tell you it is an impossibility to do a mental evaluation on someone who's under the influence. Yet we see it all the time. So that's another time we do see police take people who are drunk to the hospital, they 302 them, that's it. Even if they only stay at the hospital for an hour and then you're discharged, you're forever barred. Even if you get to the hospital, get involuntarily committed, and then tell them, hey, look, I'm fine with this. I'll voluntarily commit myself. I'll sign the paperwork. And you voluntarily commit yourself, it's already a done deal. You've already been involuntarily committed. If you get to the hospital and are able to voluntarily commit yourself, then you won't be prohibited. However, in a number of occasions, we see where people voluntarily commit themselves and the hospital still does the paperwork as an involuntary commitment. So that's another big issue. 1 second before I get back, I also wanted to touch again on the discharge. We have addressed that in a number of our letters, and that at this point, every municipality that I've contacted regarding their discharge provisions has repealed them. Dover Borough had sent back a response, and I responded to their response, and then they said, okay, yeah, we're going to repeal. But as of this point, everyone that I've been in contact with regards to discharge has repealed them.
Would it be acceptable to have an exception for self-defense?
I think that gets you beyond the Second Amendment issue, the DCV Heller. I don't believe, based on the PA Supreme Court's decision in Ortiz, it gets you beyond their decision that the entire field of firearms regulation is preempted by the General Assembly, that it's an issue of statewide concern, and as such, only the General Assembly can regulate it. It was interesting in a case that came after Ortiz, NRA versus City of Philadelphia. There, the City of Philadelphia had a straw purchaser ordinance, which is basically you can't have someone else go in and get a gun for you. It doesn't matter if you're a prohibited person. You can be completely legal to own a gun, and if you get someone else to go get the gun for you, you've just done a straw purchase, which is illegal, and it blows people's minds because you don't need to have a prohibited person involved. But in that occasion, City of Philadelphia had their own straw purchaser ordinance, which was identical to the state law straw purchaser ordinance. The Commonwealth Court, in its decision, said the Pennsylvania Supreme Court was, quote unquote, crystal clear in its decision in Ortiz that municipalities cannot regulate in any manner the possession, transport, yada yada, of firearms or ammunition. And regulation even consistent with Pennsylvania's Uniform Firearms Act is unlawful. So they struck down the City of Philadelphia's straw purchaser ordinance, even though it was identical to the state provision. Yes, sir.
On this 302 voluntary or involuntary, committing it to the cycle award, so to speak. Suppose I get to be 85 or 90, and all of a sudden my kids say, Dad lost it, and we got to put them in a home, and they sign me in, and I own 100 firearms. I can't give those firearms to anybody because I'm now committed?
Well, I don't know. I mean, again, just going to a home where you get care doesn't equate to being involuntarily.
Suppose I was 302, though.
If you're involuntarily committed, you can't have access to your firearms, but you don't lose your property right in those firearms. Now, that becomes a whole huge headache because depending on which police department or sheriff's department ends up with your firearms, getting them to send them to a gun dealer, an FFL, to sell them or to distribute them can become problematic. And based on my experience, generally requires court involvement, which is not cheap. There is a provision in Pennsylvania's Uniform Firearms Act that actually specifies that if a law enforcement department comes into possession of a firearm, knowing who it belongs to, and knowing that the individual is not prohibited, does not return that firearm to that individual, and requires court involvement, the court shall award attorney's fees. And I've been successful using that provision in the past with different police departments to get them to turn in guns, or return guns, I should say. Because one of the things we frequently saw was, especially with more rural police departments that were liberal, they would just take people's guns. Because they said, you're never going to hire an attorney to get a $300 gun back. Well, that was until they met me. And then we, yeah, they were a little surprised then when they got the letter. But that's what we were seeing, and that's why the General Assembly enacted that provision, because they wanted to dissuade law enforcement from simply taking people's guns where it wasn't evidence of a crime and the person wasn't prohibited. Now, in your scenario, that wouldn't specifically apply because we're talking about a scenario where ostensibly you were prohibited because you were involuntarily committed. So they would have to take care and safeguard those firearms for you, but the likelihood is you'd end up in court trying to get a court order directing where they're to go, unless you have a more pro-gun sheriff or police department.
Well, that happened to a partner of mine. His house was robbed, and the gun was, confiscated, and the court case was over. And 6 months later, he says, goes to the police department in Pottstown and says, I want my gun back. And they said, no, we're not going to give it to you. And he had to hire an attorney to get it back.
Yeah, that unfortunately not surprising whatsoever to me. Another topic that I know we had on the agenda for tonight that I wanted to touch base on is the confidentiality of license to carry firearms applicant information. A lot of people don't realize that your information as a license to carry firearms holder is confidential and not subject to disclosure. I recently just litigated a case against the City of Philadelphia, one of my favorite defendants, over their disclosure on an online map of individuals who were denied a license to carry and appealed, or had their license to carry revoked and appealed. That resulted in a $1.425 million settlement with the City of Philadelphia, as well as a number of policy changes to Philadelphia. As I kind of had alluded to before, Philadelphia kind of thinks they can do whatever they want. The state statute is very clear as to the criteria that is appropriate for a license to carry. It's a statewide form. Well, Philadelphia thinks they can have their own form and extra forms and require all sorts of information. Although I didn't get as much as I wanted from them, we got a number of key provisions from them, including situations that we were seeing frequently where officers would take firearms and not even give a property receipt. We also got them to agree not to require character references on the license to carry firearms application. It's been my position that even requiring those references is in violation of the law. For whatever reason, the Pennsylvania State Police, when they drafted the form, included those two character reference requirements. Nowhere within the statute do you find anything about requiring character references. What you do find in the statute is a provision that says that all license to carry firearms applicant information is confidential, not subject to disclosure. And if it is disclosed, that individual is entitled to, at a minimum, $1,000 plus attorney's fees, or if they incur actual damages, 3 times their actual damages plus attorney's fees. The Pennsylvania State Police about a year ago was asked about these references. And they said, you know what, you're right. Nothing in the law that supports their requirement on the license to carry application. But it's at the discretion of the sheriff, in their opinion, as to require them. As I said, the city of Philadelphia agreed no longer to require them, and to the extent they are submitted, they agreed they would not contact those references because, in my opinion, at that point, you're disclosing license to carry firearms applicant information, because the only way in which you have that reference's name is from the license to carry firearms application, and you're disclosing, in essence, the fact that they're applying by contacting them, giving that person's name and saying, whatever, do you know anything about this individual that I should know? So Berks County Sheriff Weeknecht has done away with them. Perry County Sheriff Nace has done away with them. There's a number of sheriffs that do not require those references because they agree they violate the law to even contact them. And let's be honest, if you're going to list references, does anyone really believe you're going to list someone who wouldn't support your application anyway? So what's the purpose? On another front, with regards to licenses to carry, this year, Perry County Sheriff Nace was sued by the county auditors, requiring that he turn over confidential license to carry firearms applicant information, as they said they could not perform their audit without having all the names. They couldn't explain why. The Sheriff Nace was providing them with a redacted copy showing all the charges, line items. They agreed they had no reason to believe that there was anything wrong with the numbers he was submitting, but they said they wanted the names and addresses of each line item, and they couldn't explain why throughout the entire litigation. When this arose, the auditors actually got representation from a larger law firm. I still believe that was funded by Bloomberg, although I've been unable to prove that. And Sheriff Nace was sitting there without any representation. He called his insurance carrier for errors and omissions, and they said, well, we're not going to represent you. You haven't done anything wrong. You've refused to give out the information. Now, if you gave it out, then maybe we would have an errors and omissions and we'd represent you. So I offered my services pro bono to Sheriff Nace. We filed preliminary objections to the complaint. There was a special judge brought in from out of county because the local judges recused themselves, saying we're too close to this between the county auditors, county sheriff, and that judge threw out the complaint, said that there was no basis in the law for the auditors to need or have that information. So we safeguarded all of that information in Perry County. And of course, we had a whole bunch of really neat trial strategies ready for the Perry County auditors that they never even knew was going to hit them if the preliminary objections weren't sustained, but that'll be for another day when another county auditors or such decide to try and get that information. So that's been a bunch of issues that's happening across Pennsylvania. We've gone over a number of bills. We've gone over Act 192, also discussed the protections with regards to licenses to carry. I'm happy to discuss any issues you have. I always like playing Stump the Chump. Feel free to ask me firearms law related issues. It's rare that I get stumped. Yep.
I have a question relating to carrying, and maybe it's not a simple question, but where can I not carry?
Okay. So first we got to kind of differentiate between federal law and state law, because we're going to have differences in where we can carry under both. With regards to Pennsylvania law, can't carry in a courthouse, but the courthouse does need to make lockers available to you to check your firearm.
Is that any courthouse?
That would be any. A magisterial district judge's office is included in that. Obviously, we cannot have a firearm in a prison, correctional facility, mental health hospital. One of the concerns with that is that ostensibly if you're in the mental wing of a general hospital, you would likely be in violation of that. So you need to make sure that you don't have your firearm on you if you are in the mental wing. However, in a regular hospital, there is no state preclusion. And why I say that is that as a private property owner, any private property owner can regulate possession of firearms on their own property. So you want to come over to my house, well, obviously this is a bad analogy because that's not going to happen, but if I wanted to tell you you can't have your firearm, you'd have to comply with that requirement. Just like certain businesses can say that you can't have a firearm in our establishment. Just like you can say that I'm spending my money elsewhere. So that's a prohibited place. One of the big gray areas is schools, because it is generally illegal to have a firearm on school property. And surprise of most, there's not even an exception for law enforcement. However, there is a defense within the statute that says that you can have a firearm on school property if it's a school shooting team or engaged in other type of extracurricular activities at the school involving a firearm, or, quote, other lawful purpose. Other lawful purpose is not defined in the Uniform Firearms Act anywhere.
Is that K through 12, sir?
Yeah, K through 12. And that's public or private. And so what constitutes another lawful purpose? I can't definitively tell you. It's my position that carrying pursuant to a license to carry is an other lawful purpose, because in our Uniform Firearms Act and in Title 18, our General Crimes Code, we state what is unlawful. Well, if it's not specified specifically as being unlawful, then it must be lawful. And under the Uniform Firearms Act, it specifically says that it's lawful to conceal carry pursuant to a license to carry firearms. It further says, in applying for a license to carry firearms, as an example, self-defense is a reason. So if I'm carrying my firearm for purposes of self-defense, pursuant to a valid license to carry firearms, that's an other lawful purpose in my opinion. However, we don't have any case law out there on it. I think the way that that needs to get resolved is through the General Assembly defining other lawful purpose as including carrying for purposes of self-defense pursuant to a license to carry, or if permitted, pursuant to open carry, things like that. That's the best way, I believe, for that to be resolved. There have been a couple cases involving it. However, and I can't say that the individuals did the wrong thing, but they've been prosecuted. One was a chiropractor recently, and the district attorney offered them accelerated rehabilitative disposition, which is basically probation, and as long as you successfully complete it, it's a non-conviction that you have the right to get expunged. If that individual litigated the case and lost, he would be a prohibited person for the remainder of his life. So in balancing that, I can't say that he necessarily made the wrong decision, but I don't think he did anything illegal. And that's really the problem that we see throughout our justice system today, is that a lot of people who really probably did nothing illegal whatsoever end up pleading guilty to crimes that they didn't commit. Before I get to you, we do have some other prohibited places. Post offices, any federal building is prohibited. There was a case out west that addressed the fact that having a firearm in the parking lot of a post office, although under federal law was unlawful, the court found that unconstitutional. Now that doesn't apply here in Pennsylvania, that was out west. So there's an argument, at least in the parking lot, but they said once you go into the post office, that was perfectly fine for the government to restrict your rights there. Any federal building is problematic. A lot of people understand that here in Pennsylvania, in national parks, as long as you have that license to carry or are complying with Pennsylvania law, you can carry in that national park. However, the problem becomes as soon as you step into any federal building, which ostensibly could be the bathroom, you just violated the law, because you cannot have a loaded firearm in any type of federal building. The other one catch-all is, wow, having some groundbreaking discussions here. One of the other issues is with national cemeteries under the Veterans Affairs. There is actually a prohibition on having firearms at any Veterans Affairs facility or controlled by the Veterans Affairs. So ostensibly, all national cemeteries are no-go zones. So those are some of the areas to watch out for. Also, it's important to remember that anytime you get into any mode of transportation, and by that I mean any mode of not public, any mode of transportation, you cannot have a loaded firearm, again, handgun on you, unless you have a license to carry firearms. So even though you're on your property, you can't get on your bicycle and ride around your own property with a loaded handgun on your hip unless you have that license to carry firearms. I used to joke around that someone couldn't be put in a wheelbarrow and pushed around because that's a mode of transportation under the law. Anything that allows you to move from one place to the other. And then it dawned on me that there's a much more egregious issue. Think about someone who's disabled, who's in a wheelchair for their life. They can never have a loaded handgun on them in any way, even holding it without a license to carry firearms. More disconcerting, most people don't realize this, but even pursuant to a license to carry firearms, you cannot have a loaded rifle or shotgun in your vehicle, ever. And the reason for that is they believe that if we do, you'll have to poach Bambi. And quite honestly, that's true. That's the reason we can't have a loaded rifle or shotgun in the car. Well, it's not just a car, it's a mode of transportation. So that also means that that person who's in a wheelchair can never shoot a rifle or shotgun without violating the law. That's what happens when sometimes the General Assembly passes bills without fully considering their impact. I believe they're trying to incorporate all possibilities, and by doing so, it's overly broad and incorporates those which, quite honestly, I believe violates the Americans with Disabilities Act and other constitutional protections. So that's something to be aware of. Yep.
With that being said, just watch the state race. That's my question. Is that still being regulated? Is that still just being regulated for the intent, the purpose of that?
So the question is with regards to what's called the SIG brace. Sig Sauer sells some rifles with a special brace that allows it to go over your forearm and be strapped on so that you can shoot an AR-15 one-handed, not having to shoulder it. That was actually designed by another company, SB Tactical, but it's sold as a SIG brace. And ATF in the past said in evaluating the product that it doesn't matter how the person uses it. It's how it's designed, what the intent was with the design. And that follows and mimics the federal law. And there was a law enforcement officer who said, well, submitted a letter request to ATF saying, what happens if I see someone shouldering that item? Because now that's a short-barreled rifle that is not registered with ATF. And ATF responded back, said, look, it's not how it's actually used, it's how it was intended, and that's consistent. They even cited prior determinations they had made in regards to how its intended design is, not how it's used. Then out of the blue, apparently because ATF was getting 10 letters a day requesting determinations, they decided to reverse course and say now that the sole determination is how it's used. And so if someone shoulders it, even assumingly unintentionally, that now constitutes a short-barreled rifle, and it's a violation of law because they never had registered it with ATF. And there's a whole slew of issues with that, because you have situations where a gun dealer may have one on display, customer comes in, picks it up, and before the dealer can say anything, shoulders it. Well, now what's the classification of that item? Technically, it's contraband because it wasn't registered before, if it truly is a short-barreled rifle. There's just so many issues. They've also said there are what they call cheek welds. They're buffer tubes with a cheek weld, so it's not designed to be shouldered, but it's designed again so that you can put it up and put your cheek next to the buffer tube. ATF has now come out and said, yeah, we believe that if those are misused, meaning touches your shoulder, it's now a short-barreled rifle. Well, what happens if you're using the cheek weld and the recoil causes it to come into contact with your shoulder? You didn't intend that, but it occurred. All these issues are out there with regards to this, and I think we're going to see some litigation against ATF regarding their determination with regards to the SIG brace.
But as of right now, I can conceal that in my car with the SIG brace on it.
Well, it depends on the criteria of the firearm, so I can't say definitively, but if it meets the criteria of a firearm under Pennsylvania's laws, so generally a handgun, yes, you should be able to do that. However, is law enforcement going to understand that and understand the measurement requirements that, you know, it has to be an overall length under 26 inches, a barrel under 16 inches, and all that? I can't say. You may end up having to fight that issue. I know there's a number of people who do that. I actually represent a gun dealer who has a Serbu Super Shorty. It's a 12-gauge shotgun that's about this big. It's an AOW. He keeps it on his thigh, on a thigh holster, and that's his weapon he carries pursuant to his license to carry. I told him, I said, you know, depending on the altercation you get in, this could really not go so well for you. I said, I think legally speaking under the statutes you're covered, but again, we get an activist judge and everything's out. So that's always one of the concerns. Yes, sir.
I'm under the impression that
you broke it.
I'm under the impression that when you have a concealed license, you cannot carry it on the outside.
I guess I'm violating the law then. No, that is a myth. You are allowed to open carry after you obtain a license to carry firearms. And I actually tell everyone that there isn't a person in the Commonwealth who isn't a prohibited person who shouldn't have a license to carry firearms. Even if you never intend to conceal carry, there are a lot of benefits under the law to having that license to carry, and it can protect you in a number of occasions. It's also state-issued ID that can be used throughout the Commonwealth and beyond to establish who you are, and it's $20 for 5 years. So I highly recommend it. Also, if God forbid something would happen, even though you don't want to conceal carry right now, maybe end up with a stalker, it sure is nice to already have that license so you can immediately go to starting to conceal carry without needing to go and apply and go through all the rigmarole. Yeah.
You were talking about schools. I have a friend of mine that is a cop, and he has patrols in a school down off of 411. I don't know if you're familiar with that area, but they have, I don't know how many people he has under him, but he has a whole slew of them in that school.
Okay. Yeah, and like I said, I've never heard of an officer being prosecuted. I don't think an officer would, but I think it's worth noting the fact that in this section of the code, there's no exception. Unlike other sections of the code, we see exceptions for law enforcement and that. There is no such exception, and that's why I think we do need to revise that provision of the statute, make it clear of what is another lawful purpose, and provide appropriate exceptions. Yeah. And now you broke it.
Yeah. All right. Sheriff Rossi in Lehigh County here. I was in there the one time, and I was getting my picture taken. And he comes over and told me, he says, I guess you're signing up for your 5 years. I says, yes, I am. He says, guys like you, I wouldn't even let in the door. You don't deserve to have a pistol. I said, is that right? Well, why did I walk in here and the buzzer didn't go off when I went through the metal detector? He says, well, I guess it's not working. I said, well, I haven't got my weapon on me, but I said I got a knee replacement, and I said nothing burped when I went through there, and I had everything out of my pockets. Now, what do you say to that? And he walked away on me.
Yeah.
So, if it was up to him.
Oh yeah, I've had plenty of issues with the Lehigh Valley Sheriff's Department. Not as bad as Philly, but still drinking more of the Kool-Aid that's equivalent to New Jersey and Philadelphia. And it brings up a good point, especially because we're going into an election cycle. With the exception of Northampton County, I believe it's the only county in the Commonwealth, our sheriffs are elected. We're responsible for it, just like our judges. And we have a number of judge vacancies coming up where judges are on the ballot. In fact, for the PA Supreme Court, there's 3 openings. We're going to have a number of Superior Court openings and Commonwealth Court openings. And that doesn't even start to touch on all the local Lehigh County Court of Common Pleas or other Common Pleas county judge spots that are open. In Berks County, we have 3. So we all really need to get out and vet those individuals who are running for judge, because they are the ones making these determinations. They are the ones who, in general, are being activists and are legislating from the bench. You need to know what their positions are. And if they try to hide behind the Judicial Code of Conduct, you know that's not a judge for you, because the Judicial Code of Conduct says they cannot tell you how they would rule in a particular situation. So if you tell them, judge, or attorney, I know you're running for judge. If I'm a landlord and the tenant comes and kicks in my door, how would you rule? He's got to say, I can't say, because that issue's not before me. I'm not a judge right now. I would have to look at it depending on the facts and circumstances that are before me. But to ask them, what's your position on the Second Amendment? Or what do you believe constitutes unreasonable search and seizure? Or things like that. They are completely able to answer those responses. In fact, Justice Scalia, in a decision a couple years back, where there was a challenge to another state's laws that precluded judicial candidates from making those comments, said, God forbid we ever see the day where the people electing judicial officials can't ask them for their position on certain issues. I mean, if you think about when a U.S. Supreme Court justice is confirmed by the Senate, all the questions that are asked there about what's your position on abortion, what's your position on the Second Amendment, how is it fine for them but not for us? Well, it is fine for us. That's the answer. But a lot will try to hide behind the Judicial Code of Conduct. So don't let them. Make sure they answer your questions. Yes, sir.
So the latest with ATFs and the green tip, 85.5 ammo. Can you hear me now? The word?
I can restate the question.
Okay. Can you hear it now? Okay, so the latest with the ATF and the M855 ammo, how they say it's going to be banned now because of the capacity to be used in a pistol instead of a rifle?
They haven't said that they're per se going to ban it. They are looking at a framework for reinterpreting whether it constitutes armor-piercing ammunition that can be used in a pistol. And there is an open comment period through, I think, March 16th for people to file comments either in support or opposition to it. I know we'll be working on a response. However, this is not formal rulemaking. This is not like prior issues this past year. We saw, well, 2 years ago, we saw what was called ATF 41P, which was a rulemaking proposal to change what needed to be submitted by fictitious entities, trusts, corporations, LLCs in relation to purchasing National Firearms Act weapons. We also saw ATF 51P, which was rulemaking where ATF was looking to potentially change some of the regulations as to what constitutes being involuntarily committed, adjudicated incompetent, things like that. So this is a little bit different, yet ATF is allowing comments. They actually had started this rulemaking like 2 years ago, and there was an official comment period back then. But ATF is accepting comments, and everyone should, respond. Once we get our comment drafted, we will, like we've always done, post it on our blog. So if people want to look at it or that. One of the interesting things that popped up with ATF 51P, the mental health provisions, was that, and I think ATF will be taken off guard, ATF just believes it has authority to regulate everything regarding firearms. The interesting aspect is actually FBI is the entity that makes all the determinations as to whether someone's prohibited or not. So in our comment to ATF 51P, I raised the issue that ATF lacked the subject matter jurisdiction and authority to even regulate what constitutes being adjudicated incompetent or involuntarily committed, because it's only FBI that can do that type of rulemaking, because they're the ones interpreting whether someone's prohibited or not. So it'll be interesting to see how they respond to that. But if you've ever had an issue at the national level with FBI and the NICS system, you have to submit everything to NICS. Even if you apply for a National Firearms Act weapon and you're denied because of your prohibited person, that goes to FBI. So it's constantly FBI that's making those decisions and determinations. So I don't believe ATF has the authority to enter into rulemaking in that context. I do believe they have the authority with regards to dealers, FFLs, and things like that. But yeah, we will post our comment once we get it drafted and submitted. Yes, sir.
Say I'm open carrying and I walk into a store or a restaurant and there's no sign saying no firearms. Who's authorized to tell me that I'm not allowed to carry in there? Is any employee allowed to tell me that, or does someone specifically have to tell me?
Yeah, any employee, any agent of the employer or the establishment can tell you to leave. And if you don't, and the police are called and you end up being charged, at that point you are looking at a charge that could prohibit you from the rest of your life from being able to own firearms. So if you're provided with oral, verbal notice to leave, you should do so. And it's always a case of where you want to spend your money. There's plenty of pro-Second Amendment establishments that would be happy for your money. Yeah. And one of the other things, kind of touching on that a lot of people bring up, is this whole idea that you are not allowed to have a firearm in an establishment that serves liquor. That's actually a myth. I think it comes from Virginia, where down there it is a prohibition, but here in the Commonwealth, there is no prohibition on having a firearm in an establishment that serves alcohol. Now, that being said, if you are carrying pursuant to your license to carry, it probably would not be the best idea for you to be imbibing in some libations while you're doing that, regardless of the fact that you may see a number of law enforcement do such. You have to remember that ostensibly your license to carry could be revoked based on the nebulous character and reputation clause merely because of that. So I just wanted to bring that up. Yes, sir.
Suppose I got a right to carry permit and I decide to go to my cabin in the mountains and I grab, 5 handguns off the rack and they're all loaded. And I put it in my car and I go up to the cabin. If I'm stopped and I get caught with the 5 and the right to carry 1, I got 6 pistols, all loaded in the car. Is that illegal?
How'd you get only 1?
I carry 1.
Right.
I take 5 off the
Right.
rack.
What's wrong with that?
They're all
It's
loaded.
licensed to carry firearms.
Okay, so they're all loaded. I can throw them in the car. I don't have to unload them.
You're a true-blooded American. Quite honestly, there's no restriction. You can have as many loaded handguns as you can possibly fit on your person and in your vehicle, and that license to carry covers it all. Can't have a loaded rifle or shotgun, but with handguns, you can have as many as you want.
Why not unload them all then?
Oh, hell no. That's too much like work. Now, let me say one other thing with regards to loaded rifles and shotguns. This came through about two and a half years ago with House Bill 40, which was our new Stand Your Ground doctrine bill that passed. The General Assembly defined what constituted loaded, because what we were seeing was a number of individuals, we'll say with an AR-15, had a soft case, put the AR-15 in the center of that soft case, would have magazines that are loaded, and put it on the outside in those zippered or Velcroed compartments. They were being stopped by law enforcement. It would, again, they violate rule number 1 that I tell them never to speak to the police, and so they tell me, yeah, officer, I got the gun in the back. And they were being prosecuted for having a loaded rifle in the car. So the General Assembly said, no, we never intended for that. That isn't loaded. So part of the definition of loaded now does not include, specifically, where the firearm is, as an example, they use soft case, and the ammunition is loaded in a magazine on a fully secured, enclosed outside compartment that's either zippered, Velcro, or something like that. So that is no longer a violation of the law. I don't believe it ever was a violation of the law, but we had law enforcement charging it, so the General Assembly stepped in and said, no, that's not what we ever intended. Yes, sir.
Are you allowed to lawfully carry in a bank, not a federal credit union, but a private bank, a public transportation system, or let's say down here in Washington, the Phantoms, an arena?
Well, obviously private property owners can restrict however they want, and I don't know with the Phantoms or that what the status of, if it's municipally owned or owned by the public or whatever. And so I can't really say with regards to that, because that's beyond my knowledge set. And also with banks, you come into the FDIC issue and whether federally being insured can cause problems with that. So public transportation again becomes an issue of who owns it. There is an interesting provision that actually is a preemption provision in 6109 M3 that says that no agency of the Commonwealth may regulate possession of firearms inconsistent with the Uniform Firearms Act. And because of that provision, last year I actually got Attorney General Kathleen Kane to issue a determination that the casino regulations that were passed by the Gaming Commission were invalid because they said that you could not have a firearm in a casino. And I said, well, that violates the law because there's nothing in the Uniform Firearms Act that says that you can't have a firearm in a casino. And so, to everyone's surprise, Attorney General Kathleen Kane probably swore up and down at me, came out with a determination, said, yeah, Gaming Commission's regulation's unlawful. Now, just because that's out doesn't mean that the casino, as a private property owner, can't restrict you from being able to possess firearms. However, what I've heard a lot from out west, a number of the casinos were glad to get rid of the restriction and have actively been promoting that they allow people to carry within them because it deters crime, and they're marketing to all those people who are pro-Second Amendment. So we also have challenges to a number of other Commonwealth agencies that have regulations, such as Department of Labor and Industry, State Department, and also the PASSHE, which is a school. Yes. So we're waiting to hear from them. Although A.G. Kane made a decision, 6 months ago, they still need to review it. And so the statutory section's a whole, 8 words long. So they've been reviewing it for a couple months now. Yep.
As far as the Phantoms game, I actually went to one recently. I did read on their website they do not want firearms on their property, and what I found out is I did leave my weapon at home the day that I went. They actually scan everyone at the door with a metal detector. I raised a concern on their website. I never got a response that they only scanned me right here, not on each side, my back, just right here, and then let me go. But I haven't heard anything since, but they do scan everyone at the door.
Okay. Well, again, like I said, it really depends on who it's owned by and whether they can regulate or not. Yes, sir.
Was I dreaming, or did I hear that either a senator or federally there's going to be a bill introduced for national reciprocity?
Yep, by a senator from Texas, name's eluding me. Coroner, yeah. I have mixed feelings on national reciprocity. I'm concerned by it because there's 3 options. One is that the laws of the state from which the individual comes applies, which means that law enforcement needs to know all 50 states' firearms laws, and they don't even know their own. The other option is that the state that you're in's laws apply, which is probably the most likely, but at that point, how does the individual learn all 50 states' laws? For example, with Pennsylvania and New Jersey, you can't have hollow points in Jersey. Well, how am I supposed to find out about that, a regular citizen, or that if I'm traveling? The third option is federal law steps in, and federal law says, if you're going to be carrying pursuant to national reciprocity, it's within these guidelines. So you can't have more than 12 rounds in a mag, you can only have full metal jacket, no hollow points, and they specify all the criteria. The problem with that is now we're eviscerating states' rights, because now the state is being stripped of the right to make those decisions as to what's right to the people. So that's why I said I don't know that there's a great answer, but...
Your scenario 2 is what it is now.
Well, they don't have to honor, right now they don't have to honor my license. Like I go into Jersey, they're not going to honor it, like we saw with Shailene Allen.
Right, but Ohio will.
Right.
So I have to know Ohio's laws if I'm going to carry in Ohio.
Yes, yes. Yeah, but
that's just being a responsible governor. You got to know
what
you're traveling through and where you're going to end up.
That's easy. That's easy to say, but the problem is the laws aren't that clear. Right. All right, and you may believe you know Ohio law. You may be surprised at what you don't know. Just like individuals who come here, and a lot of the myths that we probably dispelled tonight. People, everyone and anyone can post anything online. It doesn't mean it's true. And you may rely on it to your detriment, and that's really my concern. I think there needs to be more of a codification required under national reciprocity, where states would need to be very specific in non-legal terminology as to what's allowed and how to comply with the law, so that we don't have people violating it. Because, I mean, again, you start looking at our laws, I can have your head spinning. Yes, sir. Okay. 5-minute warning.
First, I have a statement, then I have a 2-part question. Anybody that has Representative Julie Harhart and Lisa Boscola in their districts, very pro 2A. I've dealt with them many times, so if they'll answer all your questions, don't be afraid to ask. Second, carrying a weapon in a commercial vehicle, interstate or intrastate.
Okay.
And if you were to get pulled over and you had a concealed weapon in your car, how would you proceed?
So first, with the commercial vehicle, obviously your employer can restrict, what you can or can't do in that commercial vehicle. So that's going to be one of the first issues. The second one is that federal law does provide for a protection in transporting firearms across state lines. However, a lot of that law has been eviscerated by court decisions that have said that if you don't go directly from the place that you're leaving to your ultimate destination, then any side trips actually constitute your end destination. So let me give you an example. If I'm going down to Florida, and in Florida it's completely legal for me to have my handgun, they even have reciprocity with me, I'll be able to carry my loaded handgun in Florida. But on my way down, I say, you know what? I'm going to stop in Maryland to see my girlfriend. That's my end destination for purposes of the current interpretation of federal law. And then from Maryland to Florida would be the second leg to the trip. So you can make necessary stops, fill up with gas. If you're exhausted, stop at a hotel, but you don't want to be going far off the beaten path. To the extent you want to make sure you're in very pro-gun state, stopping in Virginia or other very Second Amendment oriented states, because if that constitutes your end destination, well, if you're good to go there, you're good to go. So those are situations you want to be aware of in transporting firearms interstate. There is going to be, I think there actually already has been a bill proposed in the House, the U.S. House, to change the transportation laws to make clear to the courts that they intended it to be all-encompassing and protecting. So we'll have to see where that gets, especially with our current president. But we'll see what happens there. With regards to what to do if you get stopped, I tell all my clients, and I've spoken to a number of police officers who generally say the same thing. If you get stopped and an officer comes up to the car, I tell everyone, unless you have to go to a location where your firearm is, don't inform the officer that you have a gun, because you're taking that situation from yellow to red. Because that officer is now going to know that a firearm's involved. And depending on the officer's day and what all's happening in that officer's life, you could be in for a very rude awakening. So if the officer comes up and you don't need to go anywhere where the gun is, you have your license, insurance information in the glove box, then simply give it to them. If, on the other hand, either you have to go to a location where your firearm is, maybe you keep your gun in the glove box and that's where your insurance and registration paperwork is, or the officer asks you to get out of the car, to all my clients, hands on the wheel, and you say, "Officer, I have a license to carry." You're telling the officer you know the law. "Officer, firearms in the glove box on my right hip." You're giving the officer the information he or she needs to know about the location of the firearm. And then third, "Officer, how do you want to handle this?" Putting all the power and control in the officer, and just follow whatever they say. I've had a number of occasions where officers will say, "That's fine, just don't make any sudden movements to that location." And I've also had a bunch of individuals tell me that they had different outcome where officer wanted them to hand over their firearm. Sometimes the officer would basically empty the firearm, things like that. Again, in that situation, just leave them have the control. But most law enforcement I speak to says, "Listen, in my private life, if I get pulled over, I'm not telling the officer I'm carrying. There's no need to escalate the situation unless there's a reason for that officer to know." So that's what I always tell them. And also, while we're talking about traffic stops, rule number 1 is never speak to the police. Everyone always thinks that they can talk their way out of a traffic ticket. And you know what? In a lot of occasions, people are successful with it. And it's not that I'm against you talking your way out of the traffic ticket. It's I'm against you conditioning yourself to speak to law enforcement, because when the chips are down, your standard operating procedure is going to be to talk to the police. And the current statistics show that over 80% of criminal defendants are convicted not because of the evidence, but because of their own statements. So what I tell all my clients, whenever you get pulled over, you're going to have to give them your driver's license, proof of insurance and registration, and give it to the officer. And the first thing the officer is going to come up to you and say, generally speaking, is, do you know why I pulled you over? They're looking for you to make an admission. If you say, yeah, I was speeding, or yeah, I was going 85, guess what gets written on the back of that ticket? Admits to speeding, admits to going 85. That's it, you're done. You don't have to respond to the officer. There's no legal requirement that you do so. And I tell all my clients, respond to a question with a question. So officer comes up and says, do you know why I stopped you? Why'd you stop me, officer? Now, note, I didn't say no. Why did you stop me? And there's a reason for that. Because if they could prove that I knew why he stopped me, I've technically just made a false statement to a law enforcement officer by saying no. Now, it's very hard for them to be able to do that, but still, again, conditioning, always think, just answer a question with a question. Officer, why'd you stop me? And go from there. If the officer asks you the next question, just answer it with a question. And that's the easiest way to handle that situation. If you don't feel comfortable, officer, am I free to leave? And if the officer says no, okay, I want my attorney. And that's it. Not I may want my attorney, I want my attorney. Make sure you're very clear that you're demanding your attorney. And that's it. You don't have to say anything more to that officer. You're done. So let me give you a sample of what happened to me once. I was coming from Reading on Pricetown Road, and it goes down from being 2 traffic lanes each direction to 1 lane each direction, and they had one of their regular DUI checkpoints there. So I get stopped. Officer comes up, give him my paperwork. He says, what are you out doing tonight? I said, officer, am I free to go? He goes, does it look like you're free to go? I said, okay, can you please give me your badge number and name for the civil rights deprivation? He goes, oh, you're one of those guys. Yo, Frank, we got one of these guys who thinks about their constitutional rights that I don't have a right to stop him. Now, here's where things could have gone drastically wrong for me, and I had no control over it whatsoever. Frank knew me. Frank yells across in a dark situation, yo, that's the gun guy, let him go. Screaming gun across a highway in a night situation is not good. But thankfully, the officer kind of turned to me with this bewildered deer in the headlights look, gave me back my paper and said, get out of here. And that was it. But yeah, so that's my one example story of what to be aware of. While we're talking about police encounters, the other thing I just want you all to know, because apparently law and order has not run long enough that people have understood this, other than not to speak with the police, is that if the police ever show up at your door with a warrant, generally what they're going to say is, we have a warrant, can we come in? Now, most people don't realize why they're asking the question. Most people think, he's got a warrant, of course he can come in. Yes. You just consented to a search. Because they asked, can we come in? They didn't say, the warrant allows us to come in, we're coming in. They said, we have a warrant, can we come in? And the reason they do that is if the warrant would later be thrown out because it was issued incorrectly or unlawfully or that, then the police go in and say, well, that's okay. You can throw out the warrant. He consented to the search. Because we asked, could we come in? And he said, sure. So you always have to be aware of that. Say, officer, I'm not consenting to a search, but I understand the warrant allows you to be able to come in my home and I'm not going to impede your access. And then call your attorney immediately. So I know I'm beyond the 5 minutes that I was given, but I figured that was some good information to get out to all of you. If you have any questions, I will be sticking around a little bit later. Feel free to come up. My firm is a general practice law firm. Prince Law Office is PC, but as was stated earlier, we have a division, Firearms Industry Consulting Group, that is devoted to the protection of Article 1, Section 21 of the Pennsylvania Constitution and the Second Amendment of the U.S. Constitution. We pretty much handle all state firearm issues as well as federal issues across the Commonwealth, and any federal issues we will handle across the United States, and I actively do. I represent everyone from individuals to gun clubs, gun ranges, as well as federal firearms licensees, and I love nothing more than going toe-to-toe with ATF. So for those who don't know, there is some information, my cards and some brochures over on the table if you have any questions. And with that, I thank you all for coming out tonight.
All right, thank you, everyone. Thank you again, Mr. Prince, for joining us this evening. It was a great presentation. If you could, stick around and mingle, talk to people, sign petitions. Thank you again for coming out.
Test. If anyone here would like to contact the Bureau of Alcohol, Firearms, and Tobacco about this restriction on the ammunition, the website is APA-comments@atf.gov. That's APA-comments@atf.gov on the restriction of ammunition on the 223.
Walking around.